As part of having a successful business, it's important for you to take the time to screen all potential tenants. By doing this, you are more likely to have tenants who will pay their rent on time, be respectful of your property, follow the lease, and be good neighbors. In this segment, we'll discuss the importance of screening applicants, including the background check and the application fees. Learn how fair housing impacts how you manage your rental property. We'll also provide some safety tips when showing a potential tenant a unit. Each time that you rent to a tenant, you're making a business decision about which tenants are the best fit for your rental property. The first part of screening tenants is to develop screening criteria that are reasonable for your situation, that also meet the proper legal requirements.
When developing your screening criteria, the typical areas that we see that are screened are your credit, your rental reference, your criminal history, and your income. You may want to decide what is a reasonable credit score and what is not. You may want to outline you must have good credit, but as long as you understand, you must define what that is in your criteria. Under areas of the criminal history, you are going to decide what is a pass for your applicant.
After your screening criteria are established, it's important that you apply them evenly to all applicants in order to comply with the law. Recent changes to state law require this kind of regularized, evenly applied screening process.
What landlords want to do more than anything else is be consistent. The best tenant screener in the world would be a robot. They'd just take in information, compute whether or not the tenant qualifies, and then decide.
I suggest that people write out what their screening policies are, post it on the wall so that everyone's continually reminded. You want to be consistent, you want to be clear, and you want to keep very detailed records.
Due to recent changes to Minnesota landlord-tenant law, having your screening criteria in writing is now required if you are charging an application fee. You'll want to have copies of your screening criteria available to potential tenants who are applying for a unit.
The things that landlords or like I said, property owners need to be thinking about is when they decide that they're going to rent an apartment and they're going to screen, they need to provide tenants with the written criteria of what they're screening for. And then they need to ensure that when they collect a fee, that tenants know when they're denied why they're denied and what that's for. I think that really helps property owners, ensure that they actually have gone and done the work and they've done the screening. But it also really helps tenants to recognize what are the things that they need to work on. What are the things in their background? I've worked with several folks that didn't realize that they had negative things in their rental history. And by providing them with a list and a written criteria of that, they can go back to court and get those fixed, or they can figure out what is it that they need to do so that they can have a safe, affordable place to live.
If you charge an application fee, the amount charged needs to reflect the actual cost of doing the background check. The law requires property owners to provide written criteria to the applicant.
When you take an application fee, you must not use cash or deposit that application fee until all prior applicants have been either screened and rejected, screened and offered the unit and they've declined, and if in fact they have entered into a rental agreement with you, you must then return an application fee if you have taken more than one.
You only spend the fee as you're assessing applicants, and so you go down the line. If you look at applicant A and you approve them, then you have to return the money for B, C, and D. If you look at A and you reject them, then you go on to B and you use their money to buy the tenant screening report or to do whatever it is that you do for tenant screening.
If you charge an application fee, remember, the fee needs to reflect the actual cost of conducting the background check. Your criteria must be in writing. You must provide the name, address, and phone number of the tenant screening agency. Process one application at a time. If an applicant is denied, provide the reasons in writing. refund application fees for all other applicants who applied and were not screened. It's important to consult the landlord-tenant law for specific requirements as they pertain to the application process, including fees and criteria. There are several ways that you can screen a potential tenant. One way is to use a tenant screening company. Another way is to contact previous property owners, or to go online to search for criminal convictions or evictions.
It is so important to do the screening. With technology today, you can look up anything on your own. You can look up criminal records, you can look up eviction notices. I just find that when people have issues with the information they have to provide on a lease, they sometimes will not be always truthful. And it's very important, I think, to make sure that you're actually getting the information that you should when screening a tenant.
There are companies out there that will do the screening for you. Find out what is their fee, how fast do they get you the information, and how do they in fact get the information to you.
There are federal, state, and local laws that ensure the fair treatment of tenants in rental situations. These laws are collectively referred to as fair housing laws.
Fair housing is about a series of regulations, a set of regulations, both at the federal, state, local levels that are designed to protect against discrimination in housing. And they pertain to what we call protected class or protected classifications or characteristics like race, religion, family size, marital status. There are a variety of demographic characteristics.
The fair housing laws require that property owners and managers treat people equally. And it really comes down to running housing like a business where everyone is welcome as a customer and knows that they're being treated in a good business relationship, not because of who they are, where they're from, or that the property manager or any staff is picking and choosing people because of their favorites or any kind of bias. If I'm renting a house, I can discriminate against people based on, do you have a good rental record? Do you have enough income to pay the house? Do you have a good credit record? I'm discriminating on a good business basis of who's going to be a good tenant for me. But it really wouldn't be fair for me to say, well, I'm going to discriminate and only rent to people who are people like me. I only want to rent to people who are, well, from my church or from my background, or, you know, I'm really more comfortable with people who have my culture. That's what the fair housing laws are designed to prohibit.
It's important to realize that fair housing laws apply to a property owner's treatment of tenants even beyond the screening process. They cover the entire duration of the tenant's stay.
Very often there's some confusion about how to apply fair housing, and property managers need to be aware that it applies to almost every aspect of their business. So it applies to how you advertise your units. It applies to how you show your units. It applies to how you deal with your residents after they're living in your units. It applies to who visits your property, who visits your residents. So when I say you need to be clear and consistent, it's through the whole process.
People ask me, why should I follow the fair housing laws? Well, the do-gooder in me says you want to follow them because it's the right thing to do. The lawyer in me says you want to follow them because if you don't, it's going to cost you a lot of money. The penalties for not following the fair housing laws can include damages, can include paying the other side's attorney's fees, can include pain and suffering, can include a statutory penalty. Under the federal fair housing law right now, one violation can be a penalty of $25,000.
You'll meet many new people when you have a unit available. Because you'll be showing the unit before you do a screening, it's always good to think about your own safety. To ensure your safety while showing a unit, be aware of your surroundings. Let someone else know where you are. Keep an appointment list of everyone who calls with contact information. Take your cell phone with you. Always have easy access to the door. Park on the street and not in the driveway. Keep your shoes on in case you need to leave quickly. Arrange showings at reasonable hours. In summary, having written eligibility criteria helps you think through what you will and won't accept in someone's background check. It also provides consistency in the screening process. You heard changes in the law that impact how you collect and charge an application fee. We also discussed how fair housing laws prevent housing discrimination and how important it is for property owners to treat all applicants and tenants equally.